During court hearings, the judge made news by openly making fun of the so-called Canadian Katy Perry. His statements to the legal team emphasized how the judge seemed to have a better understanding of lyrical culture than some of the other attorneys, even in a defamation case based on rap fights. Drake's allegation that Kendrick Lamar's song, Not Like Us, damaged his reputation is at the heart of the case. Drake is accused of improper behavior in the lyrics, which are supported by images of bins on his house and the hopscotch scene with shipping containers in the music video. These depictions, in Drake's opinion, went too far. Irony, however, soon surfaced. Drake himself released a disc record called Good Riddance in March 2009, not long after releasing his breakthrough mixtape, So Far Gone. He included a number of musicians in it with the intention of harming rival rapper Aristo's career. A further dimension to the developing case is added by the parallelism between the current allegations and previous acts. It has been said that Drake was trying to terminate careers before establishing his own completely. Rap Genius claims that after claiming he no longer had time to respond to continuing disputes. Good Riddance was one of his final diss recordings. All of the featured musicians have previously had problems with rival rapper Aristo. The song is supposed to have essentially ruined Aristo's career, despite the fact that neither he nor Drake was well known at the time. Drake's last words, "Good riddance, Aristo. I just retired you," clinched the deal. The song's structure was reminiscent of LA Brianna rapping around her own failures in Eminem's 8 Mile. Drake disregarded relationships, partnerships, and pecuniary achievement, which was indicative of his early acting career as an unsigned artist still connected to Degrassi. Drake acknowledged combat defeats and positioned Aristo's shortcomings as unavoidable in the song's verses that addressed claims of flow ripping, even making reference to Joe Button, a pattern of competitive posturing that has subsequently proved essential to his career was exposed by these early actions. Drake concluded by saying, "Yes, I took an L on my own. They did not harm me. You make an effort to hide your falsehoods, like a canopy, in an attempt to subdue the 17-year-olds in Bramley." He then followed up with a hitting bar. "We don't have it out for you, but I am aware of it. All we're saying is that no one could attest to you." There were several layers of charges in this poem. Drake accused his rivals of being untrustworthy, alluded to dubious actions, and inferred dishonesty. He even suggested that they would take plea deals and snitch. In court, the song also tackled topics of underage illusions, crafting his wordplay with the concept of young females wearing private school uniforms. Essentially, the song exposed Drake's prior defeats, acknowledging that he had appropriated Joe Budden's style while also hurling scathing abuse at his rival. Paradoxically, over 10 years later, he would once again be accused of snitching and improper behavior, the very same claims he had made against his competitors. The court session under review was held on June 30th, 2025, to bring everything up to date. Even though it was more than a month ago, it is still very important in determining how this case will develop. The most important document before it was the one in which 8T's ex-legal team asked UMG for details. Thus far, the sequence is simple. The case was filed by Drake. In response, MMG filed a motion to dismiss, effectively requesting that the judge rule that the action is without merit. As a result, both parties presented their cases in the first significant hearing. Drake's attorneys retorted by outlining why the case should proceed, while UMG argued why the claim should be dismissed. The judge questioned whether the allegations had sufficient merit to proceed, how specific lyrics would be deemed defamatory in the context of the rap fights. In the end, the judge rejected UMG's move to dismiss, which permits the lawsuit to continue. New submissions were made possible by this ruling, one of which was a request for copious records from Drake's legal team. These requests include interactions with internet critics like Screwface John, claims of abuse, and correspondence between Kendrick Dave Free, and even Kendrick's kids. Well, kudos to every 12-year-old in the structure. What is going on? This is a crazy 12-year-old night. Insane. Drake's legal team started making strange demands, including one regarding what UMG knew about YouTuber and rapper Screwface John. However, the June 30th hearing itself merits more consideration before. Delving further into those papers for the first time, Drake's attorney's interactions with the judge and the judge's perspective on the case as a whole were made public. The conversation stood out because the judge's attitude almost suggested greater knowledge of rap battles than the attorneys themselves. The hearing got off to a normal start. Mike Godotel, Drake's attorney, made an appearance in court. After outlining the structure, the court mentioned that UMG had moved to have the case dismissed. Thus, Drake's attorneys would appear after UMG, and then there would be a rebuttal. The judge decided to concentrate on three main problems. First, should Drake's accusations that Kendrick Lamar's songs are libelous be regarded as views or factual statements? Secondly, if that decision could be made at this stage of the process. Third, the use of New York's Stein-Hilber criteria, which serve as the state's legal standard for differentiating between facts and views. While views are often protected speech under constitutional free expression protections, facts may be considered defamatory if they are shown to be untrue. Courts consider the accuracy of statements, their verifiability, and whether the context indicates that they are views or hints at unspoken realities, determining whether the lyrics of Not Like Us might be considered defamatory depends on this distinction. Now that the foundation was established, the attorney for UMG took the floor. They briefly mentioned two additional accusations in the case, before concentrating on Drake's defamation claim. Their main contention was closely related to the judge's previous inquiries. Kendrick's lyrics are views rather than facts that cannot be changed. Legally speaking, a non-actionable opinion is a subjective assessment that cannot be validated as accurate or incorrect, such as claiming someone is impolite. A factual statement, by contrast, would assert something provable, like claiming a person stole $500. The UMG counsel emphasized that in accordance with New York law, the court, not the jury, has the exclusive authority to decide whether a statement is factual or opinion-based, which makes it particularly suitable for resolution at this early stage. Courts frequently dismiss cases at the motion to dismiss stage on the grounds that comments are opinions rather than facts. Although New York law makes it plain that the court, not the jury, has the authority to decide whether a statement is truth or opinion. MG pointed out that Drake never made this difference in his 27-page brief. This allows the court to determine the lyrics' actionability in advance. The lawsuit may be dismissed before trial if it is determined to be opinion, while UMG contends that Kendrick's lyrics are an opinion. Drake's side maintains that they are true. The judge broke off, concurring that UMG's argument is supported by precedent. He brought up two situations, which we'll refer to as Bryan and Davis. The court placed a strong emphasis on time in the Davis case. Early in the proceedings, it was decided that a request to dismiss should be refused if the lyrics considered in their normal context may be construed as defamatory due to the objective criteria applied in the Bryan case. The whole defamation complaint was rejected. Would the remark be interpreted as truth or opinion by a reasonable listener? According to UMG's attorney, this is in line with how the courts define it. The crucial difference is whether a remark is factual or opinion, and if it has the potential to be defamatory. Broad or unclear statements may occasionally come off as defamatory to certain ears. Courts have decided that a jury, not the judge, may make the judgment in these situations. This is significant in Drake's case because it establishes the parameters for the legal interpretation of rap battle lyrics. Drake's legal team contends that Kendrick's lyrics might still be construed as defamatory even if they were opinionated in response. MG's attorney cited earlier cases in which courts have dismissed such claims early because of precedent judgments. Made in the past influence those made in the future, and for that reason, many observers perceive Drake's situation as risky. Fewens, it may change the norm for evaluating rap lyrics in court. The Davis case was cited by UMG as crucial. Court determined that the speaker's remarks suggested they possessed secret information. Therefore, that lawsuit escaped dismissal. To put it another way, comments raised the possibility of defamation since they implied information that was not just opinion. The same argument that Kendrick's "Not Like Us" is now being used by Drake's attorneys. The rabbit hole is still a profound lyric. I can go on to allude to further proof of the charge, not simply hyperbole. Real authority, a reference to an ongoing university inquiry, speaking before the conclusions were made public. And remarks that didn't seem like jokes or attacks were the speaker's main sources of credibility in Davis. The Davis case was sustained. By such background out here, Drake aims to follow that example. Because of all of that, the Davis court determined that the words may be interpreted as factual by a reasonable listener, which allowed for defamation. However, UMG contended that none of those elements apply in this instance. There is no indication that Kendrick's remarks in "Not Like Us" were supported by evidence or connected to covert investigations. The judge said, "Wouldn't these recordings always be merely opinions if context is crucial?" Does that actually comply with New York law? The location by itself, according to courts, does not resolve the matter. MG's solicitors concurred, stating that while the forum affects interpretation, it is not always definitive. For instance, courts still carefully review material even though opinion columns usually indicate opinions, although it is theoretically feasible. They contended that rap fights foster an atmosphere where severe insults are anticipated and that it is extremely improbable that diss records would ever be accepted as true statements. The lyrics of "Not Like Us" blatantly trash language that is overblown. Kendrick's lyrics, according to UMG's attorneys, were not facts but rather rhetorical exaggeration. Federal decisions and the highest court in New York provide compelling support for their views. They cited the early dismissal of a slander action against shock jock Don Imus in Hobbs v. Mass. The court did more than simply examine the text. It took into account I's infamous past and shock radio culture. Outrageous remarks were anticipated. Therefore, even if the statements could have seemed accurate on their own, they were evaluated as opinions. Here, UMG used the same reasoning. The foundation of rap fights is hyperbole. The judge, however, disputed that. He pointed out that rap diss recordings, not radio, are involved in this instance. He would have to comprehend what the average rap listener hears in order to apply the same logic. Are they fans steeped in combat traditions, who anticipate attacks yet occasionally see truth in allegations? Or are they casual radio listeners unfamiliar with rap culture? Certain lines in the history of rap have turned out to be true. The judge thus questioned his authority to dismiss the case at this early stage. Wouldn't further proof, possibly expert testimony, be needed before determining if Kendrick's lyrics might be accepted as true? UMG's attorneys resisted, emphasizing that expert testimony has never been needed in a lawsuit to determine whether claims are factual or subjective. Judges decide that for themselves by looking at the comments and their larger context in accordance with both federal and New York state law. They referenced report, where the court later relied only on the identical principal language and context, and Terrain against Liu, where the court dismissed the matter early without consulting experts. The judge noted that if the setting includes a specialized realm, such as rap fights, then this scenario may be different. He might not know enough about how fans perceive diss tunes to be in charge at the moment. Can he really tell whether Kendrick's songs are perhaps defamatory facts or just his opinion? In response, UMG's attorney stated that courts usually use the information that is already on file. This covers the complaint's wording, the actual litigation, and the background information. There is nothing else required, the attorneys contended. That context plays a significant role in defamation. Writing an essay that makes charges is not the same as a rapper making fun of another. Rapper in a diss track. They emphasize that Drake's case already includes a wealth of background information on the rap fight, including stories about his past with Kendrick and long-running rumors regarding claims of underage involvement. MG said that since the music has amassed billions of views, the law cannot be based on the interpretation of a single listener, be they a devoted fan or a casual Super Bowl spectator. Courts apply an impartial criterion. What, given the facts at hand, would a reasonable listener comprehend? For instance, in Terrain, the plaintiff attempted to prevent previous statements from being taken into account, but the court denied that request. Judges are supposed to consider the bigger picture, rather than specific interpretations. The attorneys for UMG emphasized that the court must consider the entire context, including the plaintiff's own statements, since the plaintiff included his own claims of a verbal battle in the lawsuit. The judges in the Terrain case took them into consideration here. The same idea is applicable. The rap feud, several diss recordings, and even publications detailing it are all mentioned in Drake's complaint. His own line, "That's a gift from me," about enjoying young females is also